So, time for questions. Just want to know if there's anything I did not cover. Brian's got the microphone out there, so maybe if you want to, I don't know, if you want to raise hands or line up. Line up. Okay, we'll just raise hands. Okay.
Hi. Okay. Well, I'm Mackenzie, and I work for IBM.
I used to work for IBM.
Oh,
way back.
We're all blue, right? So for us, I guess I don't do any type of federal stuff, but apparently we're federal. But for the medical and the religious specifically, they're only allowing 350 characters, which includes like spaces, periods, whatever. So, and then from there, you basically haven't done it yet, you write something, and so far everybody, they're just holding it. And apparently the rumor is, per some HR people, is that they're gonna wait, so we have up until November 8th to submit that the exemption, and then December 8th, we either have to be fully vaccinated or exempt, or we're unpaid leave. So supposedly they're gonna do the interview, or I call it interrogation, basically, I guess after November 8th. So like, what am I supposed to be putting for 350 characters?
Okay, yeah, I'm seeing a lot of that. That's the classic, your employer's trying to just box you in. I don't think that's legal, in my opinion. I don't think they're allowed to do that. It's your exemption. You should be able to tell them whatever you want. So I would say that if they're limiting you to, they're limiting you to that many characters and you can't describe your exemption, your sincerely held belief in that many characters, then they're really preventing you from entering into that interactive process. I would say that's bad faith. And so what I would do in that situation is, you can have your own letter and email it to HR and basically tell them that. And just say, hey, you gave me this form, I can't describe what I need to describe in 350 characters, that's impossible. So here's my letter, you need to consider it. And if you use my letter, it kind of walks through like, here's all the employee rights. I make it longer, one to harass the employer, because now they have to read this long thing. So we're pushing back. That's not the main reason. The main reason is I want to educate you on what your rights are, so I kind of put like all the legalities of it. This is why I have the right to this exemption, and it kind of walks through that whole process. So that's what I would do. Email your HR. I had that happen this week with a client, and HR actually got back and said, we're not going to accept this email, you have to fill out our form. And I told them, no, in certain terms, that's a blatant violation of the law, but okay, we'll play your little game. And then I, drafted a little blurb for that client. And I was like, well, they still have, if you sent the email, they have that, and that's something that would come out in a court case. So at least, like the point, there's two purposes here. One is to try to get the exemption, that's the first purpose. The second is to preserve your right to do something about it later, right? So you want to document everything. That's another really good point. Anytime you go to court, you don't want to be in a situation where it's he said, she said. That's not a great place to be in. You want it documented. So, yeah. Screenshot everything. If you have a oral conversation with your HR rep, and send them an email and be like, hey, here's what we talked about. I just want to make sure I understood you correctly. Here's what I said, here's what you said. And that kind of puts it on them to, there's a paper trail now. So that's a good thing to do.
Hi, my name is Jan, and I'm actually here for my daughter, who is very set on going to a college. It is out of state. It is in South Carolina. It's a red state. And she's an honor student, high academics. This is a perfect fit. They have a form, and the first part of it is medical exemption, the second part of it is religious, and they say this is to be only filled out for those who have not been vaccinated at all. She has been vaccinated for the childhood, measles, rubella, all those things. But she is going to a private Christian school now, so there is precedent for a religious faith background, but she does not want to take this vaccine. She wants the exemption. Do I have any chance?
So I can't really talk that intelligently about that situation because it deals with educational law, and it's not really my wheelhouse. I think that there are I'm pretty sure there are very similar protections with regard to educational institutions. I just haven't studied up that much on it, but I do believe from the limited things that I've seen that it's a similar analysis. I think that the educational institution has to make an accommodation for a sincerely held belief. I think it's very similar. So I would just, I would encourage you for, seek out your own attorney. Don't take everything I said tonight as gospel. That's my disclaimer. This is not a replacement for getting your own attorney, but I think that is the case. So.
That sounds like something that maybe you would need to research more.
Exactly, yeah. I'm happy to research that.
It's not uncommon for attorneys to have to research very specific things like that.
Believe it or not, most attorneys don't know every facet of the law. There are so many laws. People are always shocked, like, you don't know that off the top of your head? Like, do you have any idea how many laws there are? Come on. I know how to do good legal research, so I can find the answer to that for you.
Yeah.
I'm Dave with American Airlines. And I know there are several different work groups represented here from rappers, flight attendants, some other pilots. But one of the things that in the form they want us to fill out is asked, what accommodations are you willing to give us? And we're all unionized. And so for each of us to individually want to go, well, I'll do the nose swab every time before I come to work, or whatever. Or I don't think that that's our position to put anything there, because we also have unions that represent us. And I don't know if you would work with them at all, or interface at all with what party you.
So believe it or not, there's employment law is kind of separate from labor law. So that's a labor law question. It's a highly specialized area of the law that deals with labor unions in particular. So I'd be definitely willing to, if some labor unions want to talk to me and we can figure something out. I'm not sure if that was the point of your question, but I'm certainly willing to talk to union representatives and try to figure out a solution for you. But yeah, I think that is, if you're part of a union, that is something that your union would have to negotiate for you. But I mean, yeah, I don't know the answer to that question off the top of my head. I'm not sure how. Yeah, you want to clarify?
Just one other question is, American Airlines keeps claiming, we have all these federal contracts, so we have to apply to all these things. Does that slide us into federal workers at all?
So any federal law that doesn't have a provision to make an exception for a sincerely held religious belief or for a medical condition that not only runs afoul, the religious part runs afoul of the First Amendment, because that's the government making a law, making a rule, respecting an establishment of religion. So they can't really do that, and I actually put that in some of my letters, depending on the situation, because I'm like, well, okay, employer, you're going to say you're going to deny this person's religious exemption because of some federal law. Well, guess what? The federal Constitution says that the federal government can't do that. So you, by virtue of that, you can't do that either, because you're basically colluding with the federal government to discriminate against me on the grounds of my religion. And you can actually, if the government is conspiring with a private entity, there are ways to sue both. So they're not allowed to do that. They're not allowed to hide behind the federal law.
So to clarify, the people who have come tonight who are under the federal mandate that does exist through the executive order, they need to file their religious exemption, and there is protection in that for that request of accommodation. Whether you're a federal employee or connected somehow as a contractor of the federal government, is that right?
That's correct. Whether you're a federal employee, whether you're a non-federal employee, whether you work for a federal contractor, you still have those rights we just talked about under Title VII. Nobody can take those rights away from you. And it is a statute. And these mandates, they're regulations. They're not laws, they're not statutes, they're regulations. So Title VII takes precedent over that.
Mm-hmm. Okay.
My husband works for American Airlines. We just got a letter from the transport workers, and they are backing down. They are not going to put people on leave. They're going to allow them to continue work if they have the exemptions. I just got the letter.
That's great. Fantastic.
And that's because people are standing up.
So my question is, can we, and I don't know, I'm just curious. If they force you to take the vaccine, can you force them to sign something that if you die or you're very ill, they have to cover every cost. They have to cover no deductions, no co-pays, no anything out of pocket. They would have to cover everything, and they would have to cover your funeral. They would have, two things: you were sick, you were dead. They would have to do back pay. I mean, is there anything that we can do to force them to sign something? Yeah.
No, I understand the question. I've heard this a lot, and I saw, just in the various Telegram and other social media groups, this going around, have your employers sign this. I think almost no employers are going to sign something like that, and there's really no reason that they would. I mean, if I were, a company attorney, which thank God I'm not anymore, because I wouldn't want to be on this side, right? But I would be saying, no, you don't sign anything like that. There's no reason to. What leverage? And this is just the unfairness of the situation. What leverage does the employee have over the employer to make them sign something like that? Now, I will say though, whether they sign something like that or not, it doesn't mean that they're not liable. So, and this is something that needs to be looked at for other, the class action lawsuits I was discussing is suits for religious discrimination or discrimination under the ADA, but there's also the tort liability part of it where, hey, you have a situation where your employer put you in a situation where you had to decide between supporting your family and getting the vaccine, and you get the vaccine, and then you get sick or you die, God forbid, and then I think the employer is liable. They're the ones that put you in that situation. Somebody of reasonable firmness would choose to feed their family in that situation a lot of the time. And that's why we're seeing a lot of people get vaccinated. So yeah, I think and I've actually been talking with some other lawyers, actually in California, believe it or not, some conservatives out there, probably some of the last ones, about maybe doing, seeing if we could do some kind of lawsuit like that.
I work for a federal contractor, L3 Harris, and if my religious accommodation is denied, and I choose then to retire early instead of being terminated, do I lose my standing to sue later on?
So, if you voluntarily resign, then you will most likely not have the right to sue because the employer has had to have taken an adverse action against you. But in your particular situation, so you're in a situation where they said, hey, we're going to fire you if you don't get a vaccine, and you're going to lose all of your benefits, and you have the option to retire and keep them, right?
So if I retire early, then I get only a smaller portion of what my pension would be, rather than retiring at my full retirement age.
Yeah.
So it's still harm,
I would say I'd say that's a pretty good case for discrimination because they've indicated that you're going to get fired. So they've already made the decision. They've already said we're discriminating against you. And then if you retire and you're going to lose a portion of your benefits, then you're suffering. That's damages. That's what we call damages in the law. So yeah.
Two quick questions, please.
So you mentioned earlier the prospect of antibodies after recovering, right? So our company, Lockheed Martin, I'm one of those super secret squirrel guys you talked about earlier, so I have to be there for something. They give us the option to file both a religious and a medical, two separate ones, right? So the question is, is that a wise thing to do both, or should you throw it all into one? Because if I was the employer and I got both of them, I'd be like, hey, this guy's just trying to get at it, right? It makes it seem like you're going through every avenue. It may be fine to do that, but is that the smart thing to do?
Yeah, I should have included that in the frequently asked questions because I get that one a lot. And it actually just kind of brings up two questions. So one, does it hurt my claim if I file both religious and a medical exemption? I would say absolutely not. Because if you have both of them, you're entitled to do that. So why would that why would that put you in a bad light? If you can show that you are entitled to both, then you absolutely should file both of them. It shouldn't, that's not, like, you get into court and the judge is like, hey, he filed both a medical and a religious exemption. It's like, well, was he entitled to it? Well, yeah, okay, then what's the problem? So that's how that would go. And then the other point that brings up, oh my gosh, I feel like I lost it. Oh yeah, so a lot of people also said, hey, there's a lot of people, and I think this is the last question because we're out of time, but there's a lot of people that are filing kind of similar letters, like, I've had several employees use me for the same employer. Does that hurt my claim if our letters are all similar? And again, I would say, you could make that argument, but at the end of the day, it's still going to be like, you're on the witness stand. Well, is this what you believe? Yes. Okay. Well, what's the problem? Just because you wanted to make sure that it was worded in a way that was intelligent and clearly communicated to the employer, and you consulted an attorney about how to word that, I don't think that's a problem. So. All right. Well, I think if you have any other questions, I will. Oh, one more.
Yeah. Real quick. Different scenario than anybody else. I work for a big public marketing firm downtown. My girlfriend and I, we both work there. The deal was a month before COVID hit, and everybody shut their doors and everybody went to work from home. That wasn't new for us. They actually announced it as a workplace benefit to be new and cutting edge and try to draw more talent. How would that fall into this whole thing of just like you're talking about, like requesting a certain accommodation, and a safe accommodation at that, because my job doesn't change. I'm still going to be working from home. We have no plans to go back to the office, but it's also a benefit that we use to draw people in.
Yes, that's a classic, just employers shooting themselves in the foot with trying to say there's an undue burden. They have specifically said this is a benefit we're offering. So how are they going to later say, oh, well, it's an undue burden on us to take advantage of the benefit that we offered you? That's, no.
Okay, I hate to tell you this, Paul, but we're going to ask you some more questions.
Oh, that's fine. I'm fine. I just didn't want to go over the other time.
Thank you. Because we're going over the hours that we were supposed to be scheduled, but Pastor Burden said it's okay. So.
Well, if you need to go, nobody's going to judge you for going right now. But I will also stick around if you have additional questions that we don't get to cover. But yeah, go ahead.
Two quick questions. I work for Accenture, and they're doing this to us. But first question, have you seen it, or is it typical that these exemptions or accommodations are temporary and will be revisited on whatever basis?
Yes, that's another one I get frequently. That your employer, it can change over time, so they can grant. What's the basic, what happened in your situation?
Well, they haven't told us. They just said, if we do approve your accommodation, it will not be permanent. It'll be a temporary thing. We'll revisit it on some periodic basis, which they haven't defined.
Okay, I see. So it sounds like what your employer is saying is kind of like the judge with the TRO. That what's probably going on is your employer is getting flooded by so many requests, and so they're just like, we don't know how to deal with this, so we're just going to basically kick the can down the road. We'll grant it provisionally, and then we'll decide a later time. And yes, they can do that. And they can, even if they grant you an exemption, the employer can revisit that at a later time. If they find, if you get a religious exemption and then later they find something happens that, makes them you say you're a Christian and then it turns out you're out, partying and doing drugs all the time and, maybe they're like, hey, are you really a Christian? I don't know. That's just the only example I can think of. But if something changes, then they can come back and try to say we're going to revoke this exemption. Yeah, I think the expiration is really just, like I said, to kind of kick the can down the road. And they can't say, okay, this is just going to expire for all time. That's not really entering into the interactive process. They're just kicking the can down the road. So I'd be very surprised if they didn't make a decision before the expiration date.
Hey, Paul, just want to say thank you so much for the information tonight. You've already answered so many questions and given us a lot of good information. I've got a specific question. I work for a large medical manufacturing company. They just announced today, it's GE, and they've announced that all employees have to get vaccinated because they're a government contractor, and so it's some area across everybody, but they've made some good they've made ways to be able to go through for the different exemptions. I'm a sales rep, so I go into hospitals and I have to deal with this. And the hospitals have made, a lot of these local hospitals have said, okay, all of our employees, all of our vendors have to be, vaccinated. But for the last year and a half, I've done my job remotely, and I do work remotely, and there are ways of doing it without actually having to go in there. So when I request an accommodation, it's not that I need to be able to work remote. I just need to know what else I can put in there to make that accommodation for not having to go into the hospital.
Yeah, I've seen this situation a lot too. One typical one that I'll address in connection with this question, I see a lot of telehealth nurses that cover all of the United States, and all of a sudden there's now these jurisdictions like I think DC and I want to say Oregon, I can't remember else, that are basically saying we're going to revoke your nursing license in this state if you don't get the vaccine. And so then their employer's saying, well, you can't do your job anymore because the state is revoking your license. And so it's kind of a little bit similar. Your situation is more like, I can work remotely, but you might encounter the situation where a hospital says you can't come in here if you don't get vaccinated. And that could be a basis for the employer saying, well, there's this undue burden. But what you would want to do in a situation like that is you want to ask for, what would you call it? Video conferencing. Can I do video conferencing instead of doing a live visit to that hospital as a reasonable accommodation? And with, during the pandemic, it's another thing. We did everything by Zoom. So why can't we do it now? Why is it all of a sudden an undue burden to have a meeting by Zoom? We have the technology to do it, so it really shouldn't present a problem. So that's actually very important. If you do have a situation where you're required to travel, go meet with a client, go to a certain facility, and you can't get in because of a vaccine, then you would request video conferencing as a reasonable accommodation. Does that answer your question? Okay, great.
And I think we're probably going to do maybe about 3 or 4 more, and then just because I don't want to push my luck, I'd like to be able to have an event here again. So, but Paul is going to hang out up here in the front with us, and so if you have a question, if I don't get to you, if you do have a question, you can go and ask Paul.
Okay, go ahead.
So, hi, my question is it absolutely necessary to ask for accommodations when you do your exemption letter? Because I'm a home health nurse and I can't really do, video call on a wound care. I'm a hands-on nurse, so I need to be out in the field. So, exemption letter enough.
Yeah, so you're like, it's not just, if you screw something up with your initial request, like you don't request the right accommodation or whatever, it's not like it's a one and done type thing. It's an interactive process, so it's supposed to go back and forth. So you might say, well, hey, here's the accommodation that I suggest. Yeah, can I wear a mask? Can I get a regular testing or something? And then they'll come back and say, well, we think this is okay, we think this is not okay. Another thing that you could do, and this is what I was going to say about the situation where we have these telehealth nurses that are required to practice in all these states, you could say to your employer, well, one, is there another position within the company that I could work 100% remotely? Now the law says if you request an accommodation, and I had this happen a lot at Goosehead, actually. I had to move some people around because something to do with their situation, they couldn't perform that specific job. But if your employer, if there's another job that's open that they're qualified for, the employer actually has to put you in that job if it's available. Now in this situation, it's gonna be a little tougher because you have a lot of people in the same situation, so maybe there's not all those open jobs. But I would request that as an accommodation, and just anything you can think of. Just get creative, like, well, what if I did this? What if I did that? Just keep the conversation going. Yeah.
Hello, thank you. God bless you for standing in the spiritual warfare. So I work for Raytheon, I'm in management, and I'm so tempted that whenever they send out that email that says the vaccine clinic is coming, at this and this date, I just want to blast everybody and say, don't do it. And so legally, what grounds do I have? It gets under my skin that I'm in management and like I'm not advocating this. So if I were to post things in my, you know, in the building, or how can we tell other, you know, people, colleagues, and stand up for, you know, an opposition against this in our workplace?
Okay, so this actually does touch on labor law, which, again, I'm not an expert in labor law, but I believe it is the case, I'm pretty sure. I'd have to research this a little more, but in the, what's it called, I can't remember the name of the statute, the NLRA, National Labor Relations Act. It does give employees have the right to organize. And so you actually do, now it can't be like disruptive to the workplace, you know, but, and don't take this verbatim, I need to do some more research on this, but I believe it is the case that if employees want to organize, and it's not absolutely just, you know, disruptive to the workplace, I don't think they can prohibit you from having conversations like that. I think that is actually a violation of the NLRA. So maybe follow up with me on that, and I can do some additional research.
So, Paul, there's a question that really I think is a great follow-up to this question that you had.
Hey, Paul, thank you. So I work for a financial institution. When I log in to do my job, so talking email, anything that I do online with them, likely the exemption form that we'll have to submit, all of it will be behind the firm's firewall and behind the firm, you know, within a virtual session. We've signed agreements saying that everything that we do is property of the firm. You know, you can't, you're basically locked from printing anything out and taking possession of it. You couldn't take a screen grab off your own computer. You can't kind of do any of that, right? So when you're talking about documentation, how would you recommend approaching that situation in the, you know, days and weeks leading up as mandates and emails are coming out, and then after you've kind of submitted everything that you need to submit? You know, I wouldn't want to show up with a notepad and kind of get laughed out of, you know, out of remediation, but at the same time, I wouldn't want to show up with, you know, stuff that I've taken pictures of and have them come back and say, hey, you stole that from us, right? So how would you think about that?
Yeah, that's a tough situation, because your employer actually has a legitimate reason to keep you from doing that. And so if you violated that, you know, those rules, then your employer could fire you and you wouldn't really have any recourse. You couldn't say, well, I was just doing it to preserve my legal claim, because the employer does have an actual business reason for doing that. And so I think the best thing you can do is, you know, emails are all discoverable now. I mean, we know sometimes employers are naughty and delete emails, so they can get in big trouble for that in a lawsuit, but just best you can, document every conversation, send a recap. I would always tell, when I was an HR director, I mean, that's the #1 problem in employment law. You get into a lawsuit with these employees and there's no documentation, and it's just a he said, she said. It's terrible. And so I would tell my managers, hey, you have a conversation with an employee, send them a recap email. So just make sure and do that, because those emails should be discoverable. I would also, I don't know if your employer prohibits this, but you could like keep a diary, like just of yourself. Like you could just say, hey, today this happened, and just write it down, date it in your handwritten notes, and then at least you have some kind of written record of stuff that happened. I mean, that is evidence. So it's not like you're, you know, making up off the top of your head after the fact. So it's a little weightier than testimony.
And Paul, we have
Okay. I lost my job over a year ago from the most conservative place there is, Bass Pro, and I had ADA accommodations, so they let me work a few extra days because I wouldn't wear the muzzle/mask, couldn't wear it, wouldn't wear it, and they sent their insurance company after me, said they wanted my medical and mental health history not to wear it, which I don't know how I would have ever got that, because I didn't talk about my past trauma with my medical doctor. Anyway, what I used at the time against that insurance company was called a Conditional Acceptance letter, and I said, if you can prove that nobody else will see this, my medical mental health history, then I will give it to you. If you can prove this, I will do this, and if not, you need to start paying my unemployment, which they did. But my question is, okay, my boyfriend, long-term boyfriend, is at Southwest. He's at management. Because I can't wear the muzzle, and I will not take the jab because they aborted fetal tissues. This has caused major issues in our relationship, major. So can we go after these people for alienation of affection or oppression? And can he use that conditional acceptance saying, can you show me that Jody's not going to leave me stuck here with this house once I take this? If you can prove it, or something to that effect. And also, should we be attaching affidavits to the thing that you're handing out? Those two things, the conditional acceptance and the affidavit.
Okay, so the alienation thing would go to, if you were in a lawsuit, it would go to your damages. So, let's say that, your boyfriend got fired from, Southwest took some adverse action against him. They made him, wear the mask, they made him do all this stuff, it caused problems in their relationship.
Can you wait for me to get one guy over
what
here
triggers an
against you,
employment
and
law
then
claim is when there's an adverse action taken against you. That can be anything. That's a detriment to the changes the conditions of your employment, a reduction in pay, a demotion. If anybody's seen Office Space, they kept moving that poor guy with the thick glasses, to yeah, some of you get the reference. That would be an adverse employment action, and so that triggers the right to sue. And then so that's what's called your legal claim. And then you have the damages part of it, and that's all the things that you suffered as a result of that adverse employment action. So mental anguish is a big part of it. Hey, this blew up. I mean, it's like claiming I'm in a lawsuit against Goosehead right now. It's part of my claim. They fired me, and I was engaged at the time. It blew up my relationship. I'm no longer engaged. It was a very, very difficult thing to go through. So that's part of my, my legal claim, my damages. And then the conditional acceptance thing, I've never heard of. I'm not sure how to answer that. I'm not sure I really understand what you're asking. So maybe you just ask me after that, and I can get a little more, or after this, and I can get a little more clarification.
Paul, we're on the final two questions right now.
Those two and then two right here.
Okay.
Sorry,
So question regarding COVID tests. There's Texas law for discrimination for genetic information in tests, and specifically that an employer can't take adverse action if you refuse to take a genetic test. Are the PCR tests or the antigen tests, do they qualify for that? And is there any recourse on that?
Not that I know of. What you're referring to is called GINA, the Genetic Information Something Act. I'm not intimately familiar with it. I know the employer cannot discriminate against you on the basis of anything to do with your genetics. As far as I do remember actually doing a CLE on this, continuing legal education, when I was HR director, and there was nothing, they said that you could actually do the PCR test and it didn't violate GINA. I don't remember what the whole reasoning was. Go ahead.
GINA doesn't stop tests that are refusal for testing, but the Texas version of it does.
Okay.
So
I'm not aware of that statute, so maybe give it to me after this, and that's something I probably want to take a look at. So, thanks.
real quick. Can y'all tell I'm bossy?
Hi, Paul. Thanks for having this workshop. It is perfect timing as I'm facing a deadline of next Friday of submitting my request for an exemption. My question is, how confidential is that information with my employer outside of HR? I have an immediate supervisor that I understand would probably need to know, but the vice president of my region also wants to know. How appropriate is that information to be shared with my team?
Yeah, so HIPAA does does protect your privacy. So really, it's only the people that need to know. So if somebody doesn't need to know and HR is sharing that information with them, I mean, yeah, they could get in trouble for that. I mean, there are criminal penalties for HIPAA. It's a very extensive statute. So. Oh yeah. Oh yeah, no, if I was your HR person and I heard about that, that manager would be in trouble. I'd be like, you need to walk it out, sir. So, yeah.
Hey, Paul. So I'm seeing a lot of employers are going and they're using voluntary resignation. If you don't, they're saying you voluntarily resigned if you do not get an exemption. If you don't choose to get vaccinated, that's instead of using adverse employment action, as you're saying, or being fired. What kind of action can you take against that? Because if they're saying you're resigning, you can't really sue them based on discrimination.
So if you're, I think the question is basically your employer's kind of like forcing you to resign. Is that, yeah, that's just called a termination. There's no such thing as a forced voluntary resignation. That's a termination. So it's just, that's an adverse employment action. Yeah.
Okay, last question.
Thank you so much, Paul, for this evening. The question that I had is the religious exemption was based on your body being the temple of the Holy Spirit, as I understood it. What about people that they would say, well, look, your body's the temple of the Holy Spirit, you drink, you smoke, you chew, you overeat, you don't exercise. What are your thoughts regarding that as an objection from the employer?
Yeah, no, it's a really great question. So there, you are, again, you're entitled to your own religious belief. And so all the things that you mentioned, they can look bad. Most of the time, your employer's not really going to know about those things. That's usually your personal life. But if they do, and they point, hey, you smoke, isn't that, that could hurt your religious exemption, to be quite honest with you. But I think that the argument here is this is not something that's just gonna, there's a change, smoking, yeah, you have a high risk of lung cancer. Are you absolutely gonna get it? No. This is something that fundamentally changes the way your cells function. So I think it's a little bit different because this is genetic material you're putting in your body that's instructing your cells to do something that they otherwise would not do. Now, so I guess to sum it up, yeah, it's not great if your employer knows that you're doing all of these things that are harming your body, and now you're all of a sudden saying, well, I'm violating the temple of the Holy Spirit. Yeah, that's probably not gonna, that's an objective basis to question your belief. So if that's you, just do the best you can to argue that the vaccine is worse than all those things.
That's a good question. I know there are more questions. Paul is going to be here. I know you have a question too. And I hate to say no. And Paul and I are both helpers. So I know that y'all, this is so important. So, Paul.
I'm not tired. So people, you're free to leave if you want. I'm happy to answer a few more questions. I really doesn't bother me.
Okay. All right, let's do these last two. And then if you have a question that we didn't get to as a group, please go up to Paul and ask him, because as we're packing up and leaving, those conversations can take place. Okay?
What's the ceiling for a company for undue hardship? Like, what would be their threshold?
Anyway, if you want, before I answer the question, I want to say, if you're going to leave, I do have a bunch of business cards out there if you need to get in touch with me. Also, make sure and sign the sheet so we have your email if you're not on Eventbrite. But anyway, I'm sorry, I got totally distracted. Can you repeat the question?
It's like, what would the ceiling be for their threshold for undue hardship?
Oh, okay. Yeah, actually, that's an important question. So there is a difference between a medical exemption and a religious exemption when it comes to undue hardship. And this just blows my mind. So the Supreme Court of the United States has said that an employer only has to show more than a de minimis burden to overcome a religious exemption. So it's basically that's almost anything if they can show kind of a burden. So you really have to show, hey, there really is no burden in providing this exemption. I think Texas case law is a little better on that. So you can, and this is, we have a federal system, right? We got federal law, we got state law. So you can actually, a lot of people, these United Airlines and the Southwest Airlines, they're sitting in federal court under federal law. I just don't know why they're doing that. I think that Texas courts and Texas law is going to be better. So if I was going to bring a class action, I would bring it in the Texas courts. I think Texas will offer a little bit better protection in that situation than federal law would. But it's hard to say what the exact burden is. It's basically something that, I'm trying to remember the exact legal language. For medical exemptions, it has to be something that's pretty bad. Like it has to cost the employer a lot. Like if you want, like here's an example. And if you go on the EOC's website and type in, guidelines for religious exemptions, they have a lot of examples that you can kind of go off of. But like, I had an employee that was sensitive to smell, and so they wanted like a smell-free workplace, basically. So it's like, that's not really something we can do. We can't really change the whole building and do, so if it costs the employer a lot of money, that's generally nothing. It's usually.
Okay, I think we're gonna wrap it up. So, thank you everybody for coming, and Paul, thank you so much. Pastor Burden, thank you. Paul needs water. Someone go get him a bottle of water, please. Okay. And I'm gonna give y'all one thing to do. When you leave tonight, when you go home tomorrow, you call your state senator and you call your state rep and you tell them you want a ban on vaccine mandates. We're gonna be up front. If you have any specific questions for Paul, grab his card. He'll be up there to maybe answer a few more questions. But thank y'all for coming. I hope that it was very informative to you. And anyway, we'll be up front.
Thank you so much. I really appreciate it.